In this session, we will see about the surety's liability. A surety, by his contract of guarantee, agrees to perform the promise of another person or discharge the liability of another person in case he fails to do that. So his liability starts at that time, but his liability, according to section 128, is coextensive with that of the borrower. So long as the borrower is liable, this person is also liable. If the borrower, by acknowledgement of debt, agrees to extend the time, acknowledgement of debt, the documents are kept alive, documents are not, debt is not time barred. In that case, the surety is liable. If the borrower reduces the liability, the surety's liability is also reduced. Reduction will result in reduction in the liability of the surety. Same way, if there is a condition precedent in signing the documents, then if the condition is not fulfilled, the surety will not be liable. In one case, a National Provincial Bank versus Brokenbury. In this case, he was told that there are 3 guarantors, but actually there was only 2. One person has not signed. Since the person has not signed, the surety escaped the liability. It was held that he is not liable. In another case, one of the surety's signature was forged. In that case also, surety was not liable. Then regarding that liability, even though the surety's liability is coextensive with that of the debtor, the surety has no right to ask the creditor to proceed against the debtor and then come to him. The creditor has a right to proceed against the debtor alone or surety alone or against the surety and also the debtor jointly. It is the right of the creditor. Creditor can file suit against the surety, get back all his money. In that case, the surety has to file a case against the debtor and he has to recover money. The creditor cannot dictate terms to the surety cannot dictate terms to the creditor. It is creditor's right whether to proceed against the debtor or the surety or against both. The debtor has a paying capacity is not an excuse. It is a creditor's right. That is, the surety before signing should know about all the borrower's dealings. Then only he should sign. That is why, in case of default, this surety has to perform. Next is the right to limit his liability. The surety has a right to limit his liability. He can say the borrower may be borrowing 1 lakh rupees. He can write, my guarantee is only for 50,000 rupees. If he is not remitting the money, I will pay you only 50,000. He can put any condition also. In one case, that is Florence Mabel versus State of Kerala, the person borrowed money for bee culture. It was a failure. He could not make a payment to the creditor. The surety's defense was, it is a impossibility of performance, could not be done, so it should be treated as void agreement, so I will not be making payment. But the court held, you have, that person has borrowed, you have guaranteed the amount, you have to make a payment. This is regarding surety's liability. Now we will see about the continuing guarantee and bank guarantee. Continuing guarantee is a guarantee where the guarantor promises the debt of the other person where the transactions are there. There are 2 types of guarantee. One is specific guarantee and another is continuing guarantee. Under specific guarantee, there is only one transaction. For example, one person goes to the bank, borrows 1 lakh rupees, promises to pay in 10 months as 10,000 each. If a person guarantees that, it is a specific guarantee, specific only for the 1 lakh transaction, and in case the person remits 5 months 10,000 each, 50,000 his transaction, his remittances will make the surety's liability also reduced. In another one is a continuing guarantee for a series of transactions, guarantee is given. For example, one person, businessman, will go to the bank, open a current account and allow a credit limit of 1 lakh. That is, the person can draw money anytime up to the amount of 1 lakh. He can remit money and he can take back his own money, or he can remit money and apart from the money remitted he can draw 1 lakh rupees. When he goes for a purchase he will take 1 lakh rupees, but after the sales he will deposit the sale proceeds, 50,000 rupees sale proceeds, and again he may remit another 50,000. Now the loan is nil, 0, because he has remitted 50,000. When he goes for the next purchase, he will go to the bank and take the 1 lakh amount. Again sale proceeds will be remitted, balance will be 0, and again he will take. This continuing guarantee guarantees all the transactions. If it is specific guarantee, once the money is taken and when the money is remitted, guarantee becomes invalid. Because guarantee is for the 1 lakh rupees, he has taken 1 lakh, he has remitted 1 lakh. But this is a series of transactions. Under continuing guarantee, the guarantor is continuing to guarantee the series of transactions. This can be revoked. Specific guarantee cannot be revoked. This can be revoked. Revocation can be made by a notice. The revocation will be effective from the date of notice. The guarantor will be liable for all the transactions taken place prior to the date of notice. This is regarding continuing guarantee. Next we will move on to the bank guarantee. Like individuals guarantee the other person, banks may also issue a guarantee. For example, a person has taken a government contract to build a bridge. Then the government will ask for a bank guarantee. Bank will issue a bank guarantee. We promise to pay you 50 lakh rupees on demand from you. In case something happens, in case this person is not doing the construction work, you make a demand, we will make a 50,000 rupees. This is a guarantee issued by the bank in favor of the other person. If there is any problem, they will send a notice to the bank. The banker has to make payment. But normally these banks will delay this. They will ask for a court order and all. But in one case, Hindustan Steelworks Construction Limited versus Tarapur Limited. In this case, Supreme Court has told this bank guarantee is independent and distinctive guarantee. You need not wait for the court order. Your guarantee promise is an absolute promise to make a payment. You need not wait for a court order. Once the demand is made, you have to make a payment. And in this case, Supreme Court advised other courts also, don't give injection, don't interfere in payment unless otherwise fraud is there, or if permitted, it will be a liability for the other person, injury, permanent injury to the other person. In that, selectively you interfere. That was advice given by the Supreme Court to the other courts. But whenever there is a fraud, they can do. In Banerjee and Banerjee versus Hindustan Steel Limited. In this case, claim was made, but they have not given the details about the claim. Just they send a notice they want to invoke. In that case, it was not given because it is a fraud. Kirloskar Pneumatic Limited versus NTPC. In this case, a bid was given, guarantee also given, but subsequently the bid was revoked by the person. They have withdrawn the bid. But the company wanted to encash the bank guarantee. Court held it is not possible because once the bid is withdrawn, before acceptance, there is no contract. You cannot invoke the guarantee. You cannot get payment for the guarantee amount. Regarding the Limitation Act, so far as the borrower is liable to that creditor, the guarantor is also liable. with regard to the guarantor, the liability, the period of limitation starts from the date of notice. Once the guarantee is invoked, from that date only the limitation period starts. Now we will see a next topic in the next session.